Welcome to the How to Fight Your Charges criminal series. I am attorney Natasha Scruggs. I'm a criminal justice expert and a criminal defense attorney located here in Missouri, and I'm the founder and CEO of the Scruggs Law Firm. We're here to talk about today the first step in how to fight your charges, and that is reasonable suspicion and probable cause. In order to further illustrate this point, we have a video, which normally we don't have video footage of something of this nature. But someone was recording when an officer attempted to make an arrest, and actually he did make an arrest on a civilian who was innocent. And he's the victim in this case, and I would love to show you him.
Niggas catch me out here sipping on this motherfucking Arizona and shit, you know what I'm saying? Just kicking it, waiting for my nigga Moore to come through, shoot this TTT shit.
In this scenario, the victim did nothing wrong. He was merely standing in the parking lot drinking a tea.
Word. Get Cuzzo out. Huh? Drink. Look at the tea. What's wrong with you?
Yeah, you got alcohol in there?
Oh, ain't got no alcohol in it. You see this is it. Look at sweet tea, pink lemonade.
Just make sure.
Who is you?
Police.
Now, him drinking the Arizona tea is not a crime. However, when the individual came over there to check to see what was going on, he assumed that it was alcohol. Now, once he described to him that this is tea, showed him the can and showed him the ingredients, at that point, there was no reasonable suspicion. Reasonable suspicion has to be observations. As he observed the can, he noticed that this is a can of tea. Maybe when he was further back, he didn't know that. But at this moment, reasonable suspicion is done.
Ingredients. Look and see what it is.
I want to do it. You ain't got to show him.
Go to the
You ain't
gas
got to
station
show
and
him.
see what it is.
First of all, he's an
Go
officer
to the
cop.
gas
You don't even know if he's really a cop.
He ain't show me no identification for no reason.
Leave the property. You got 5 seconds to leave. I can shoot you property now.
Yeah, for what though? What's the crime?
We got the camera.
What's the crime?
Reasonable suspicion must be observed behavior. It cannot be merely a hunch. A hunch is not sufficient to establish reasonable suspicion. If someone merely has a hunch, then it is likely that that search, that arrest, could be thrown out and it might be illegal.
You got 5 seconds left. Put your hands up against the car. Put your hands up against the car now.
touching you, man.
Put your hands up against.
If the officer didn't have reasonable suspicion, then of course he doesn't have the even higher standard of probable cause. Probable cause would be after he's investigated and after he's gained some evidence. As you can see, he didn't get any further evidence that would suggest that the victim had alcohol, but instead he aggravated the situation and decided to throw charges on him of trespass.
On nothing, man.
Sir,
Yo.
put your hands up against the car. You're under arrest.
Yo, for what? I'm about to go. Yo, you want to drink this?
You're under arrest.
For what? I ain't doing
Because I
nothing,
said
man.
you trespass.
I'm about to get, yo. Yo.
You're under arrest.
Yo, what? What? For what? For what? For what?
Resist delay obstruct.
For what?
Put your hands behind your back, sir.
For what, though?
Put your hands behind your back now.
For what? I
Put
ain't
your hands
doing
behind your
nothing,
back.
And this is an Arizona iced tea. I want everybody to see this.
Yo, he can drink the contents.
Half and half Arizona iced tea.
This is trespassing, sir.
For what? I'm about to go in the store.
Probable cause is something that a lot of people heard about but may not know. And this is what I wanted to tell all of my clients because it will help them not in the moment, but in preparing for your case. If you understand what the standard is, then you'll understand what to do and how to inform your attorney. A lot of these things occur because the clients may not know what the standard is. And probable cause was defined under the 4th Amendment of the United States Constitution. It is applied to all United States citizens. Probable cause occurs when the facts and circumstances would lead a reasonable person to conclude that a crime is afoot, a crime had been committed, or a crime is about to be committed. This is only the first step in beating your case. And the Scruggs Law Firm and other law firms around the state and around the country use this information. In this case, his charge was dismissed, but it took a long time, about 18 months, and he lost his job. The officers will have to have reasonable suspicion or probable cause in order for detainment, arrest, or subsequent searches. And if they don't have this information, anything obtained from those searches can be thrown out. Next week, we're going to talk about step 2 in fighting criminal charges. Again, my name is Attorney Natasha Scruggs.